approved September 9, 1850, an act to establish a territorial government for Utah. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all that part of the territory of the United States included within the following limits, to wit, bounded on the west by the state of California, on the north by the territory of Oregon, and on the east by the summit of the Rocky Mountains, and on the south by the 37th parallel of north latitude, be, and the same is hereby created into a temporary government by the name of the Territory of Utah, and, when admitted as a state, the said territory, or any portion of the same, shall be received into the Union, with or without slavery, as their Constitution may prescribe at the time of their admission, provided that nothing in this act contained shall be construed to inhibit the government of the United States from dividing said territory into 2 or more territories, in such manner, and at such times as Congress shall deem convenient and proper, or from attaching any portion of said territory to any other state or territory of the United States. Section 2. And be it further enacted, that the executive power and authority in and over said territory of Utah shall be vested in a governor, who shall hold his office for 4 years, and until his successor shall be appointed and qualified, unless sooner removed by the President of the United States. The governor shall reside within said territory, shall be commander-in-chief of the militia thereof, shall perform the duties, and receive the emoluments of superintendent of Indian affairs, and shall approve all laws passed by the legislative assembly, before they shall take effect. He may grant pardons for offenses against the laws of said territory, and reprieves for offenses against the laws of the United States, until the decision of the President can be made known thereon. He shall commission all officers, who shall be appointed to office, under the laws of the said territory, and shall take care that the laws be faithfully executed. Section 3. And be it further enacted, that there shall be a secretary of said territory, who shall reside therein, and hold his office for 4 years, unless sooner removed by the President of the United States. He shall record and preserve all the laws and proceedings of the Legislative Assembly hereinafter constituted, and all the acts and proceedings of the governor in his executive department. He shall transmit 1 copy of the laws and 1 copy of the executive proceedings on or before the 1st day of December in each year to the President of the United States, and, at the same time, 2 copies of the laws to the Speaker of the House of Representatives and the President of the Senate, for the use of Congress, and in the case of the death, removal, resignation, or other necessary absence of the governor from the territory, the Secretary shall have, and he is hereby authorized and required to execute and perform, all the powers and duties of the governor during such vacancy, or necessary absence, or until another governor shall be duly appointed to fill such vacancy. Section 4. And be it further enacted, that the legislative power and authority of said territory shall be vested in the governor and a legislative assembly. The legislative assembly shall consist of a council and House of Representatives. The council shall consist of 13 members, having the qualifications of voters as hereinafter prescribed, whose term of service shall continue 2 years. The House of Representatives shall consist of 26 members, possessing the same qualifications as prescribed for members of the council, and whose term of service shall continue 1 year. An apportionment shall be made, as nearly equal as practicable, among the several counties or districts, for the election of the council and House of Representatives, giving to each section of the territory representation, in the ratio of its population, Indians excepted, as nearly as may be. And the members of the council and of the House of Representatives shall reside in and be inhabitants of the district for which they may be elected respectively. Previous to the first election, the governor shall cause a census or enumeration of the inhabitants of the several counties and districts of the territory to be taken, and the first election shall be held at such time and places, and be conducted in such manner as the governor shall appoint and direct, and he shall, at the same time, declare the number of members of the council and House of Representatives to which each of the counties or districts shall be entitled under this act. The number of persons authorized to be elected having the highest number of votes in each of said council districts for members of the council shall be declared by the governor to be duly elected to the council, and the person or persons authorized to be elected having the highest number of votes for the House of Representatives, equal to the number to which each county or district shall be entitled, shall be declared by the governor to be duly elected members, or the House of Representatives, provided that in case of a tie between two or more persons voted for, the governor shall order a new election to supply the vacancy made by such a tie, and the persons thus elected to the Legislative Assembly shall meet at such place and on such day as the governor shall appoint, but thereafter, the time, place, and manner of holding and conducting all elections by the people, and the apportioning the representation in the several counties or districts to the Council and House of Representatives, according to population, shall be prescribed by law, as well as the day of the commencement of the regular sessions of the Legislative Assembly, provided that no one session shall exceed the term of 40 days. Section 5. And be it further enacted, that every free white male inhabitant, above the age of 21 years, who shall have been a resident, or said territory, at the time of the passage of this act, shall be entitled to vote at the first election, and shall be eligible to any office within the said territory, but the qualifications of voters, and of holding office, at all subsequent elections, shall be such as shall be prescribed by the Legislative Assembly, provided that the right of suffrage and of holding office shall be exercised only by citizens of the United States, including those recognized as citizens by the treaty with the Republic of Mexico, concluded February 2, 1848. Section 6. And be it further enacted, that the legislative power of said territory shall extend to all rightful subjects of legislation, consistent with the Constitution of the United States and the provisions of this act, but no law shall be passed interfering with the primary disposal of the soil. No tax shall be imposed upon the property of the United States, nor shall the lands or other property of non-residents be taxed higher than the lands or other property of residents. All the laws passed by the Legislative Assembly and Governor shall be submitted to the Congress of the United States, and, if disapproved, shall be null and of no effect. Section 7. And be it further enacted, that all township, district, and county officers, not herein otherwise provided for, shall be appointed or elected, as the case may be, in such manner as shall be provided by the Governor and Legislative Assembly of the Territory of Utah. The governor shall nominate, and, by and with the advice and consent of the Legislative Council, appoint all officers not herein otherwise provided for, and in the first instance the governor alone may appoint all said officers, who shall hold their offices until the end of the first session of the Legislative Assembly, and shall lay off the necessary districts for members of the Council and House of Representatives, and all other offices. Section 8. And be it further enacted, that no member of the Legislative Assembly shall hold or be appointed to any office which shall have been created, or the salary or emoluments of which shall have been increased while he was a member, during the term for which he was elected, and for 1 year after the expiration of such term, and no person holding a commission or appointment under the United States, except postmasters, shall be a member of the Legislative Assembly, or shall hold any office under the government of said territory. Section 9. And be it further enacted, that the judicial power of said territory shall be vested in a Supreme Court, district courts, probate courts, and in justices of the peace. The Supreme Court shall consist of a Chief Justice and 2 Associate Justices, any 2 of whom shall constitute a quorum, and who shall hold a term at the beat of government of said territory annually, and they shall hold their offices during the period of 4 years. The said territory shall be divided into 3 judicial districts, and a district court shall be held in each of said districts by one of the justices of the Supreme Court, at such time and place as may be prescribed by law, and the said judges shall, after their appointments, respectively, reside in the districts which shall be assigned them. The jurisdiction of the several courts herein provided for, both appellate and original, and that of the probate courts, and of justices of the peace, shall be as limited by law, provided that justices of the peace shall not have jurisdiction of any matter in controversy, when the title or boundaries of land may be in dispute, or where the debt or sum claimed shall exceed $100, and the said Supreme and District Courts, respectively, shall possess chancery as well as common law jurisdiction. Each district court, or the judge thereof, shall appoint its clerk, who shall also be the register in chancery, and shall keep his office at the place where the court may be held. Writs of error, bills of exception, and appeals shall be allowed in all cases from the final decisions of said district courts to the Supreme Court, under such regulations as may be prescribed by law, but in no case removed to the Supreme Court shall trial by jury be allowed in said court. The Supreme Court or the justices thereof, shall appoint its own clerk, and every clerk shall hold his office at the pleasure of the court for which he shall have been appointed. Writs of error and appeals from the final decisions of said Supreme Court shall be allowed and may be taken to the Supreme Court of the United States in the same manner and under the same regulations as from the circuit courts of the United States, where the value of the property or the amount in controversy, to be ascertained by the oath or affirmation of either party or other competent witness, shall exceed $1,000, except only that, in all cases involving title to slaves, the said writs of error or appeals shall be allowed and decided by the said Supreme Court, without regard to the value of the matter, property, or title in controversy, and except also that a writ of error or appeal shall also be allowed to the Supreme Court of the United States from the decisions of the said Supreme Court created by this act, or of any judge thereof, or of the district courts created by this act, or of any judge thereof, upon any writ of habeas corpus involving the question of personal freedom. And each of the said district courts shall have and exercise the same jurisdiction in all cases arising under the Constitution and laws of the United States as is vested in the circuit and district courts of the United States and the said supreme and district courts of the said territory, and the respective judges thereof shall and may grant writs of habeas corpus in all cases in which the same are granted by the judges of the United States in the District of Columbia, and the first 6 days of every term of said courts, or so much thereof as shall be necessary, shall be appropriated to the trial of causes arising under the said Constitution and laws, and writs of error and appeal, in all such cases, shall be made to the Supreme Court of said territory, the same as in other cases. The said clerk shall receive in all such cases the same fees which the clerks of the district courts of Oregon Territory now receive for similar services.